Dr. Monique Chireau.
Yes, thank you. It's an honor to... Thank you. It's an honor to be here today, Senator Blumenthal, Senator Grassley. My name is Dr. Monique Chireau. I'm on the faculty of the Duke University Medical School. I'm also a practicing obstetrician, gynecologist, and a clinical researcher. S1696 could reasonably be interpreted to invalidate virtually any type of current state laws which place restrictions on or regulations on abortion. It would also endanger healthcare providers' freedom of conscience. It would prohibit the future enactment of such protective laws. The purpose of the bill, as we've understood, is to protect women's health by ensuring that abortion services will continue to be available. Implicit in the statement, in the stated purpose of the bill, are the four following assumptions. Number one, which is that abortion is good and safe for women. Number two, that state abortion restrictions and regulations are medically unwarranted. Number three, that access to abortion is important to women's health. And number four, that the state has no interest in protecting unborn children. I will address each of these in turn. The Centers for Disease Control define an induced abortion as an intervention performed by a licensed clinician that is intended to terminate a suspected or known intrauterine pregnancy and produce a non-viable fetus at any gestational age. The U.S. Supreme Court has repeatedly acknowledged that abortion is inherently different from other medical procedures because no other procedure involves the purposeful termination of a potential life, and that the abortion decision has implications far broader than those associated with other medical treatment. Assumption number one is that abortion is good for women. However, a substantial body of literature indicates that induced abortion is associated with significant risks and potential harms to women. It's stated to be very safe at early gestational ages. However, in a very large study from Finland of 42,619 women, the maternal mortality rate from abortion was 14.1 per 100,000. Approximately 20% of the women in this study underwent severe adverse events such as hemorrhage and infection. Among these women, were included both surgical and medical abortions for these women. These statistics represent a significant burden of disease, and if these results were extrapolated to the United States, that would be 260,000 adverse events per year. Further research has also demonstrated that the risk for abortion performed at greater than 21 weeks is greater when performed at 21 weeks than at lower gestational ages. These risks range from about 0.1 in this to 0.4 per 100,000 to 8.9 per 100,000. However, because of problems with the denominator of this study, the results cannot easily be extrapolated. The point is that late abortion carries a 77 times increased risk for mortality compared with early abortion. And that is a significant issue. This is mortality. This is not morbidity. This is death. Other complications can occur following abortion. Induced abortion in a first pregnancy, as we have heard earlier, increases the risk of preterm birth. There's also a robust literature on mental health problems following abortion. These mental health problems include anxiety, depression, and so on. Assumption number two is that state abortion restrictions regulations are medically unwarranted. States have a compelling interest in protecting the health of their citizens, and they have the authority to do so within regulatory frameworks, including state medical boards and departments of health. Historically, states have regulated medical procedures by establishing standards for training and credentialing. These standards protect patients from injury and death. The fact of the matter is that patient-physician interactions do not occur within a vacuum. The issue of whether patients have access is a two-sided issue, a two-edged issue. This is because access can be, you can have access to care which is inadequate, being performed by incompetent practitioners, or you can have access to good care. And zip codes do matter. In many zip codes in the United States, patients have access to care which is inadequate, which endangers their health. This bill would not protect the rights of patients because it would remove the ability of states to regulate the practice of medicine. In addition, the scope of practice for different types of clinicians is carefully defined. Recently, there have been attempts by mid-level practitioners in several states to assume the role of providing abortions. Again, this particular bill would remove the ability of states to monitor and supervise the practice of medicine through abortion. One of the questions that comes up in any of these discussions regarding the need for improved regulation, including monitoring of the access to clinics, widths of hallways so that emergency personnel can enter buildings, is what is there to fear from complying with the law? If laws are enacted in order to protect the health of patients and the health of patients, and to protect really practitioners as well by providing them with the appropriate conditions to practice in, what is there to fear in this circumstance? The question really is, to what extent are we willing to surrender states' ability to regulate laws regarding the provision of medical care? Finally, the fact that the state does have an interest in protecting unborn life is not acknowledged in this particular bill. There's no mention of unborn children at all, in spite of the fact that the purpose of the bill is to eliminate most regulations or restrictions on abortion. The Supreme Court has recognized since Roe v. Wade that the state has an interest in the potentiality of unborn life throughout their pregnancy. This is because unborn children and their mothers are vulnerable to injury, exploitation, and social disadvantage. We care about whether a nurse who is mixing chemotherapy is exposing her fetus to potentially carcinogenic or teratogenic drugs. And this relates to the interest around when pregnancy begins. If we do believe that pregnancy begins at conception, rather than at implantation, which is our standard medical definition, we need to begin to consider how to best protect the fetus at early gestational ages. Similarly, neonatologists are pushing back the boundaries of neonatal viability. This bill does not take into account these scientific advances because it removes restrictions on abortions at various gestational ages. So in my conclusion, I would like to say that S-1696 is a measure that seeks to overturn long-standing state restrictions on abortion that have been supported in the courts. It ignores not only widely supported policies and scientific evidence, but also prior Supreme Court rulings, and clearly targets state regulations which protect the health of our most vulnerable citizens, pregnant women and their unborn children. All access is not equal. Zip codes do matter because we want patients' zip codes to provide, practitioners within zip codes to provide care that is sensitive, affordable, comprehensive, and competent. Thank you.
Thank you, Dr. Chireau.
Dr. Chireau, some states have laws on the books that would require providers of abortion to be located near a health facility in the event that medical care is needed, and that would probably involve the life of a woman. Some states also require abortion providers to have admitting privileges to hospitals. First of all, do you agree with the laws? And then secondly, could you elaborate on why they make sense in your expert medical opinion and tradition?
Yes, thank you for the question. So all too often, and this has been my experience as a practitioner, when abortion complications occur, patients are told to present to the emergency room. They're not given any documentation. No one is told what was done and what the complications were. This has happened to me in practice. A patient experienced perforation of her uterus during a late abortion, had a very complicated hospital course, and I called the abortionist and asked, why did you do this? You knew that you perforated her at the time. And essentially what he told me was that he knew that he did it, but that he didn't want to send her to the emergency room. And I said, that's really malpractice. That's not appropriate. And again, his response was, well, she started moving. I said, that's your issue. If a patient is moving during a procedure, that is your issue. You should be performing a procedure in such a way that it's comfortable. But to get to more directly to respond to your question, I do believe that physicians should have admitting privileges because that is part of the standard of care. If you perform a procedure on a patient, if you are caring for a patient, you need to be able to follow up on the complications of that procedure. That is a surgical maxim. As an OB/GYN or a general surgeon or whatever surgical specialty you happen to be in, you need to take responsibility for that patient if they have a complication to either admit them to the hospital and care for them yourselves or arrange for transfer to the hospital so that that patient can be taken care of. Transfer agreements are very important because they provide for continuity of care. And this is why I believe that physicians, A, need to have admitting privileges, and B, need to be able to be located within a hospital so that the patients can be managed. So there are a couple of issues here. Number one, admitting privileges imply a level of competence in clinical practice on the part of physicians. If physicians cannot obtain admitting privileges, there are reasons why, and that's why peer review is generally the rule when patients are applying for privileges. When physicians cannot get privileges, it is most often because there are issues of competence, they have a trail in their background of malpractice events that causes their peers at the hospital to say this person is not someone that we want to be on the medical staff. Hospital credentialing protects patients. Hospital credentialing requires that a physician has demonstrated competence in doing specific procedures and that they are not running from medical boards or running from adverse actions on behalf of their licenses. Physician-to-physician communications improve the process of care. One of the major problems with morbidity and mortality in any surgical specialty, medical specialty, is the handoff. It's like a baton handoff in a race. If you fumble the handoff, you lose the race. If you fumble the handoff in medicine, patients are injured. Admitting privileges allow for discipline. If physicians are practicing outside the scope of practice, if their skills begin to deteriorate after time, admitting privileges provide for a regulatory framework where physicians who are in trouble or causing problems with patients can be disciplined. And this is one of the reasons why I think many people in the abortion industry oppose credentialing, because it exposes the fact if they are not competent, if they've had excessive numbers of complications, if they have a trail of injured patients and lawsuits, this is going to be exposed. And then finally, I think that it establishes the fact that if you cannot get privileges, you cannot meet the standards for medical practice. Finally, an important issue is that being on a hospital staff or being on a medical part of a medical society implies that you're part of the medical community. If you're outside of that medical community, then clearly something's wrong. There's some other issue going on. I hope I've answered your question.
Dr. Parker, is it standard medical practice for physicians operating on a child at 20 weeks to provide anesthesia to that child?
Well, Senator, I'm not well versed in fetal surgery because most surgeries at 20 weeks would have to occur in utero.
Yeah, well, right, they would. Ms. Chireau, are you familiar with what would be the standard of care there?
Yes, it is, and that's because when fetal surgery is done, and I'm very well aware of the fetal surgery landscape, initially when fetal surgery was being done, fetuses reacted very strongly to incisions, to placement of catheters.
So standard medical practice to provide anesthesia when you operate on a baby at 20 weeks?
Yes.
Medical encyclopedias, and I'm sorry I'm running over, I'll wrap it up here, encourage parents to talk to the baby at 20 weeks. They can hear sounds, they react to your voice, they can hear your heartbeat as a mother, they can hear your stomach growling, and they can react to loud noises. Does that make sense to you, Ms. Chireau?
Yes, it does.
Okay. Has anyone ever been born at 20 weeks that survived?
As far as I'm aware, no.
Not to my knowledge.
I can show you twins. Thanks.
Dr. Chireau, this bill sounds like it is very deferential to medical judgment and that abortion should be treated like any other medical procedure. But under this bill, politicians, lawyers, and judges would make final decisions on such things such as which medical procedures are, quote, comparable, unquote, which tasks doctors may delegate to other personnel, which drugs may be dispensed, which medical services may be provided through telemedicine, how many visits to a medical facility are necessary, the relative safety of abortion services, which methods advance the safety of abortion or the health of women more or less than others. Now, from your perspective as a doctor, doesn't this bill actually compromise the practice of medicine?
I think it does compromise the practice of medicine, and I believe that's on two levels. Number one, for the reasons that you've enumerated. Number two, because I do believe that current legislation in the states to set clinic, specify access to clinics, and so on and so forth, is protective to patients. So I think that it's doubly a problem. Number one, for those reasons that you've listed, and also because the regulations that have been enacted were enacted in an attempt to prevent abortion providers from being exempted from the same sorts of regulatory frameworks that other medical practitioners have to operate within.
This bill would prohibit restrictions on abortion that are not also imposed on what it calls medically comparable procedures. Now, that is just one of the key terms in this bill that are brand new and completely undefined. But this bill makes a pretty clear statement that there is nothing unique about abortion, nothing that makes it different from any other medical procedure. And that, of course, is not true,
That's
whether
correct.
you're pro-abortion or anti-abortion. Even in Roe versus Wade, the Supreme Court said that the state has unique reasons for restricting abortion because it involves what the court calls potential human life. And in Harris versus McRae, the Supreme Court in 1980 held that the abortion, quote, is inherently different from other medical procedures because no other procedure involves the purposeful termination of a potential life, unquote. I don't think that we need the Supreme Court to tell us that, but there it is. Doesn't that settle this question and completely undercut the entire theory behind this bill?
Yes, I believe that it does, and I think that the issue of comparable procedures is really false. I believe that abortion is a unique procedure. As you've said, it is the only procedure that terminates a human life. In addition, from the technical perspective, an abortion is a very different procedure from, say, completing a miscarriage or doing a dilation and curettage on a non-pregnant woman.
Okay, Mr. Chairman, could I ask just a couple more questions?
Sure.
I know that there are just two of us here.
We're approaching a vote, and Senator Cruz is here, so...
Well, I didn't see Senate. Well, let me just ask one more. The Supreme Court created one set of rules in 1973 for evaluating the constitutionality of abortion regulations. Then the court changed the rules in 1992. Now, this bill creates yet another standard, prohibiting regulations that a state cannot show by clear and convincing evidence significantly advance the safety of abortions. Now, it's bad enough that the Supreme Court sometimes does Congress's job, but here's Congress attempting to turn around and do the court's job. But it gets worse. This bill applies its rules and regulations to all state and federal statutes, to all state and federal regulations in the past, in the present, and in the future. Does this mean, for example, that states would be required to repeal any laws or regulations already on the books that do meet these new rules?
Yes, sir, I think that that's a very important point. I think that essentially this law guts states' rights with respect to abortion. It creates abortion as a special protected class of procedure and abortion providers as a special protected class of providers.
Well, I can't imagine why any state legislature would support this, no matter their position on abortion.